Case on this morning's docket. That is case number 107596, State of Kansas v. Talkington.
May it please the Court, Stephen J. Atherton on behalf of Cyrus Talkington. Your Honor, this matter is before the Court on a petition for review of a Court of Appeals decision that overturned a district court suppression order. This was a curtilage case. Essentially, Mr. Talkington rode the coattails of his co-defendant and successfully argued that a search by law enforcement on his co-defendant's property constituted an unlawful search of the curtilage of that property. Our contention is that the Court of Appeals, when they reviewed it, essentially reweighed the evidence in this case, specifically the done factors to determine whether it was a curtilage situation. Both the District Court and the Court of Appeals agreed that the proximity from the home favored the argument that it was curtilage because it was essentially a 3 to 5 feet distance from the location of the concealed or partially concealed contraband to the back door of the residence. But where the Court of Appeals, we believe, reweighed things was when they started looking at some of the other factors. Specifically, the district court found that while there weren't the 6-foot fences around this property that apparently the Court of Appeals would have liked to have seen for a curtilage case, the court found that there were barriers there, a boundary wall, partial chain link fence, and some trees that could obstruct the view and or dissuade people from entering into the property. And the court said that based on that, he gave no weight to that particular factor. The Court of Appeals said that it weighed in favor of the state because there was no attempt to maintain privacy in the area. Here we certainly believe that the Court of Appeals reweighed evidence in this case.
And this really isn't a plain view case, is it? From outside the boundaries, there's no allegation that the officer could see and identify this meth, was there?
No, I believe that I believe it was Deputy Dowdigan, had to enter onto the property. The meth was located underneath some insulation and had been partially concealed. He had to lift it basically to determine what the baggie was, but he was on the property when he did so. The other areas, again, the nature of uses of area that Dunn set out, the trial court found that there was no evidence of what the nature of uses was. I think the testimony was it was kind of junk-strewn backyard, not anything really setting it out as being any fencing or anything like that.
Was there any evidence of usage in the backyard?
I'm sorry?
How the backyard was used other than this junk?
I don't believe there was any evidence of that, although if I recall correctly, I believe my client testified that he had been over to work on mopeds and vehicles, and I think the assumption would be it would have been in the backyard given the small front yard involved in this case.
Okay, thank you.
He didn't actually say it was in the backyard?
I don't believe so.
That's a deduction. Okay.
How do you distinguish these cases with, I think it's Orr and King, where we've held a glassed-in porch? I think King was a partially screened-in porch, is not a part of the curtilage. And I understand that there's a distinction there because they're issuing a warrant. I think in King, came out onto the semi-enclosed screened-in porch, and we held it was not, well, affirmed the Court of Appeals and said it was not curtilage. How do you distinguish that?
If I recall correctly, one, you're not seeing what you're seeking in this case. In other words, this was concealed underneath some trash or something of that nature. Secondly, in this case, we have the no trespassing sign. And obviously the trial court gave some big consideration to that. Here you have a clear expression that the owner of the property did not want anyone on the property. No trespassing. There was also no soliciting sign. Those were right out front. I believe Dowdigan testified he couldn't see him, but he went right by him to go back into the backyard.
Has the landscape changed any because of the Florida versus Jardines case in 2013, U.S. Supreme Court case, basically that said that resurrected the traditional property-based viewpoint? That case found that a porch was part of the curtilage.
Which I wouldn't disagree with. And here.
But if we have that, if we look at the property, baseline property analysis, does that still leave us to consider the Dunn factors? That may be an unfair question if you're not familiar with the.
I'm not familiar with it, but I think that the Dunn factors would still be applicable to determine how close you can be to the house, if you will, and what would constitute curtilage under those circumstances. I know this court has had curtilage cases previously where it wasn't right next to the house like we have here. And the court found that it was within the curtilage because of attempts to conceal or something of that nature. So I don't think that the Dunn factors are out the window at this point. As I said, though, I really think under these circumstances what the Court of Appeals did was just sit there and look at the factors, and they didn't say that there wasn't substantial competent evidence to support the court's findings. They simply said the court weighed them wrong. And that is not correct. That's not what the Court of Appeals had the right to do under the stated standard of review that they had. The Fourth Amendment is there to protect the expectation of privacy. Obviously, these individuals, in attempting to conceal this evidence, were exercising their right to privacy in this case. Plus they had, as I said, the trespass sign out and things that they attempted to limit the ability of people to enter onto the property. If this court agrees that the trial court, under the appropriate standard, made the correct decision, I think you still need to address the other two issues that were raised, being the standing and attenuation issues. The Court of Appeals didn't deal with those, but certainly the standing issue, I don't think, there's no Kansas law that I'm aware of on point on a curtilage issue with standing. I think under the circumstances and based on the evidence that standing exists in this case, and we agree with the district court's finding that it did. And certainly the attenuation issue, I think, is a non-issue because there's no break in the chain between the arrest of the defendant, taking him to the jail, and then searching him at the jail and finding the additional contraband.
Well, Garrison,
I'm sorry. Excuse me. The search only occurred because he was arrested, right?
I'm sorry?
The search that uncovered the marijuana only occurred because he was arrested.
Correct.
On standing, would it be appropriate for us to remand to the Court of Appeals for an evaluation of that issue since it didn't reach it? Or because it's a legal issue, we should keep it? Or do you have an opinion on that?
You have all the information in front of you that they would have. I don't see any reason why this court couldn't just make that decision.
Okay.
Garrison he lived there,
Correct.
the co-defendant.
Yes.
And Talkington was just visiting him with social guest, is that correct?
Correct.
Okay.
And I believe that was stipulated by the state. In short, we're asking this court to affirm the trial court in this case and to reverse the Court of Appeals decision. If there are any other questions?
I see none. Thank you,
Thank you.
counsel.
May it please the court. My name is Jonathan L. Noble. I'm Assistant Lyon County Attorney I'm here today to ask the court to affirm the decision made by the Court of Appeals, find that the property was not curtilage, and that the seizure and the resulting search of Mr. Talkington was valid.
What was the standard of review governing the Court of Appeals?
The standard
decision?
of review was a mixed standard, as set forth here by in Fisher, that the factual underpinnings of the district court's decision is to be reviewed by a substantial competent evidence standard, and that the ultimate legal conclusion drawn from those facts are subject to a de novo review.
So in what way were the findings of fact of the district court deficient under that standard?
The findings of fact, in fact, this is almost a stipulated fact situation. The evidence that was presented in Garrison was by agreement of the parties just entered into this case. There was not really any factual dispute of the material facts. And as set forth in Coleman and announced again in King, when the parties do not dispute the material facts, the suppression question is solely one of law. And because the Court of Appeals had de novo review and had the ability to apply the law to the facts and come to a legal conclusion, it did not improperly weigh the evidence.
So that portion of the analysis that is a decision on whether the facts support the direction a factor cuts is a legal question?
That is a legal question.
So there's really what's going on when curtilage is being examined under the Dunn factors, assuming that's even appropriate given my colleague's question about the later U.S. Supreme Court case. Then there's a layer. The first layer is to find facts, which you're saying didn't have to happen here because they were undisputed.
That's correct.
And then there's a legal question over how those facts cut on each factor. And then the overall question, it's also a legal question.
That is correct. There isn't in fact, Dunn itself says that the factors don't produce a finely tuned formula to mechanically come out at the correct answer. It's an analytical tool that determines a central question, whether or not the area that is being alleged to be curtilage is so centrally tied to the house that that intimacy should be taken under the umbrella of Fourth Amendment protection.
Mr. Noble, could you comment on Justice Johnson's question to Mr. Atherton concerning the Jardine case? Are you aware of that, or is that something you're prepared to argue?
I'm not prepared
Okay.
on the Jardine case. If the court would like, I'd be happy to prepare a supplemental brief on that issue.
I'm going to ask you to restate what you said was what I would call the second step in the standard of review. Could you restate that for me, please?
Yes, Your Honor. Okay. The ultimate legal conclusion drawn from those facts is... I'm sorry. I'm starting over in my notes. They review the factual underpinnings by a substantial competent evidence standard.
That's the first step.
And then the second step is they review the ultimate legal conclusion drawn from those facts by de novo review.
All right. Well, I'd understood that there was a third step that you were providing to Justice Byers' question. Did I misunderstand you? Or are you saying that what was stated in Fisher is what you're relying on?
What I'm stating in Fisher is what I'm relying on. The question that she asked as far as the factual situation, there is a standard set forth in Coleman, 292 Can, 813, and then again restated in King, that when the parties did not dispute the material facts, the suppression question is solely a matter of law. And if it's solely a matter of law, then the standard of review should be de novo, and the court should have unlimited review over it.
So it would be your position that since in this case the facts are undisputed, the only issue for us to look at is whether we independently conclude that there was curtilage.
That is correct, Your Honor.
Thank you.
you agree with your colleague that plain view didn't come into play here?
I do agree. The facts are undisputed.
It seemed to me that the Court of Appeals was looking at, to be curtilage, you have to preclude a plain view observation. Would you agree that that was their focus, where their 6-foot privacy fence comment?
I think their focus was whether or not steps were taken by the residents, which is the fourth factor in the Dunn test, to maintain some reasonable expectation of privacy.
But it's also taking steps to delineate what is your property. It seems to me that if you let it be known to third parties that this is my property, say a retaining wall around, even if it's a foot high, lets the public know that this is my property, does it not?
It does. It is, in fact, I think it was described as like a boundary marker at one point rather than a wall.
It seemed to me that the panel sort of disregarded that aspect, that there was a delineation of, hey, this is my property, this is part of my curtilage in my mind, and instead said that it has, the boundary line has to also impede observation.
I would say that would be a fair characterization of the Court of Appeals opinion.
And would you agree with that assessment?
If curtilage is supposed to be something that's so intimately tied to the expectation of privacy that a person would have in their house, then I agree that there should be some effort on the part of the resident to secure some privacy in an urban area, especially.
So everybody has to build a house like they build them in Dallas, where they tear down the little one and they put one clear up to the property line in order to protect the entire. I mean, is that really what has to happen?
No, as the Court of Appeals indicated, some sort of privacy fence, some sort of indication that this property was used in a way that is normally associated with homeowners, specifically
Wealthy homeowners.
Yeah.
Wealthy homeowners. Have you priced fencing lately? It's really high. I think there's a cartel. So
Is that in the record?
no, but I'm just saying, there is an impact here. That if the rule has to be you have to fence it to have it be your home and it's curtilage, there are a whole bunch of people going to be cut out of that rule, aren't there?
I agree that that could be cost prohibitive, yes.
That's my only question. Thank you.
The issue about the signs, you haven't really talked about them. It's pretty unusual to see signs posted in the front of the house saying no trespass and no solicitors. I guess they're less expensive, but
Well, the signs were there in the front. There's no question about that. There's no question that the signs would be observable from the back, or there weren't any signs in the back. The officer's testimony was that he didn't see the signs when he went on the neighbor's property. And then once he entered onto the backyard, he
actually had to go onto someone else's property, didn't he?
He went onto someone else's property
To get to the back of the house.
to get to the back of the house. Stepped over the 1 foot boundary marker. When he got 30 to 40 feet away, maybe 50 feet away, he saw the white baggie. And it was only when he got up to about 5 or 6 feet away from the baggie that he made the identification that he led him to believe that it was methamphetamine. There's no dispute that that was in 2 to 3 feet of the house itself.
And that's why I think you may need to take a look at the Jardines or Jardines case, because it talked about the porch being a classic example of the area to which the home life extends. And I would, 2 or 3 feet around your house, it's hard for me to view that as not being the area within which your home life would extend.
It's a 2013 case. It has the potential to remake curtilage law.
Mr. Noble, I noted your office didn't appeal the Garrison case from Judge Larson's order. Your position on that, of course, I mean, it has nothing to do with the standing issue, right? I mean, if it's curtilage no matter what, who lives there or who's visiting?
It is. And the question of the standing, in reviewing my colleague's brief and the arguments they put forth on the standing issue, it seemed to me, and I will concede this, it seemed like to me that the argument was it wasn't curtilage, therefore there was no standing. There wasn't a specific, I didn't really track with my colleague's standing argument, and I will admit that. However, I also was not able to find specific case law that would help direct the court at this point.
Standing's a separate issue. That's the even if we were to say that it is curtilage, you still have a standing argument.
That is, we believe so.
Okay.
Do you have any further presentation? on
I do
any
not,
issues?
if there's no further questions.
Any more questions? Thank you, counsel.
Thank you.
Thank both counsel for your arguments this morning. Court will take this matter under advisement.